but this is unpaid wage claims. If you retired from Palco or you were terminated from Palco a month before bankruptcy and were promised they'd keep you on the payroll and pay your severance for 6 weeks, that's unpaid claims, but is it an unpaid wage claim? You're not still working. Well, here you might rather that your lawyer could go to Oakland and argue it than Corpus Christi. I don't know the answer to that, but it's certainly possible that a large portion of it is a priority claim. And I wish I had a better answer for you, and I wish I had a more reassuring answer for you. Other than note holders, who are the other secured creditors? On this chart, there's $36 billion under the Bank of America. That's a credit taken out in connection with the notes, and the money is used to help make payments on the notes, but it's owed to Bank of America, and they are also secured by the real estate. So, we've said all night long, the land has to be worth more than $1,716 million. That's not, there's a couple of details. It actually has to be worth more than 750, because you got 714 owed to the note holders and 36 to B of A. But there's another gimmick too. They've got a pile of cash which is dedicated to the notes. Remember how much is in that? They got $24 million to just set aside to pay notes. So from 750 you subtract 24, and really the number's 726. That's complicated, and I'll go over that after the break if you want. It's really a question of how much secured debt is on this company, and it's at least the amount owed to the note holders, plus the amount owed to B of A, less the amount that's in a cash account that they have a direct claim against. There's also some secured debt at Pacific Lumber itself. That's the debt that's at Scotia. The debt at Pacific Lumber is this piece of paper says $100 million to Marathon Finance. I don't know if that's true. I'm not as familiar with Palco as I am with the debt at Scotia. But that would be the other secured creditor. How is the chairman of the creditors committee chosen? The members of the committee elect the chairperson. Why are lawyers allowed on the committee? Who could have a problem with that? The people on the committee are the creditors. So Jones Company or Alice Landowner, who Palco owes money to. They're the creditors, unsecured creditors, so they're not the note holders, unsecured creditors. They're the 6 or 7 largest creditors. But you can't have a company sit in a room. So the company gets to select a representative. Some companies will select a lawyer to go sit in a room, because if you're, the lawyer might be able to participate more, contribute more, or they don't want to do it, so they'll send somebody else, and the lawyer's the only person. So there's no prohibition against lawyers participating in creditors. But the member of the committee is not the individual. The member of the committee is the company or the individual that's owed the money. Most hypothetical discussions on bankruptcy that I have heard are framed as if the company filed for bankruptcy because of something fairly innocent, lousy management, or financial difficulty. Financial difficulty is probably more innocent than lousy management. What happens if this is not the case and there's been strategic and intentional mismanagement? Is the case managed differently? Could Malcolm Horowitz be penalized or disadvantaged in the proceedings for this reason? Again, I don't know anything about Horowitz or Maxim, so I can't testify as to who did, or speak as to who did what to who. I told you on a chart that has since been erased that after Chapter 11, it's normally business as usual. Management stays in place and continues to operate the company. If there has been gross mismanagement or fraud, the court can kick out that management and put in a trustee to run the company. That happens in Chapter 11, but it happens very rarely. And there's a bias in the courts to allow management to stay in place. But it certainly happens that if in the days before bankruptcy, the owner of the company is taking money out of the till, the courts will appoint a trustee. I think it's unlikely to happen in this case. If the debt for equity occurs, will the management change? Probably, well, hard to say, hard to say. If there's a debt for equity exchange, there will be, the old note holders owed $800 million, or 716 or whatever, will have new notes about $200 million, assuming that's a level that the company can support, and they will get the stock. The shareholders of a company, in America, under corporate law, the shareholders get to elect the management. The note holders may say, we like the president, the vice president, the chief financial officer, and the general counsel of the company, and we'll keep them. But shareholders shareholders elect the board of directors, and the board of directors appoint the management. The shareholders will almost certainly change the board of directors, because the board of directors are now, as I understand it, largely maximum appointees. So they will probably change the board of directors. Whether it'll be a decision of the board of directors whether to keep current management or not. And that's 5 hypotheticals down the road, right? You have to have a debt for equity exchange. New local level management. Well, I would think if they had a brain in their head, they would pick people local who knew what they were doing. How long is the company under the protection of Chapter 11, and what happens after? That's that's a great question because it's a summary of everything we talked about. The company will be in Chapter 11 until the plan is confirmed. Normally that takes, in big cases like this, 1.5 years or 2. But it could be quicker, and especially if the note holders win this single asset real estate issue. But normally it'll be a while. And afterwards, the company continues to operate, hopefully with a new business plan, and hopefully with a sustainable harvest rate, and hopefully with a debt structure that it can carry. Has there been or will there be an inventory to document PALCO's current timber inventory showing the rate of cut since the '86 takeover? There will certainly be the harvest rate, the historical harvest rate, and the projected future harvest rate will be a subject of innumerable discussions and arguments and lawyers and briefs and everything. But what has been, and it's actually already happened, and what has been to date, Mark or some of these people can tell you better than I, because, like I say, I'm a bankruptcy expert, not a PALCO expert, but I can tell you that question goes to evaluation and it goes to feasibility. Harvest rate is a critical issue for both of those.
And our understanding is that their current inventory information is now part of the fishbowl. So the inventory GIS information that up to now has been, whatever it's called, proprietary, is now open and public to the creditors committee and their attorneys to look at as part of the valuation. Is our read on it, which is significant.
And the land be valued as real estate or sold off to pay operating expenses. Both are true. Valuing the land, when you value, like I say, if it's a pickup truck, you go to the Blue Book. It's a piece of cake. Real estate, you have to figure out how you're going to value it. And you have to look at alternative uses for the real estate. We don't cut a single tree, we turn it into a great big park and charge $1 admission at the gate to go in and look around. Well, it's a fabulous park, but it's not worth very much, because the $1 admission, if you took in all the gate receipts, it's not going to generate a lot of cash. So that's not a very good use for this property. When you say valuing it as real estate, I'm not sure if you mean for real estate development. Certainly, if this property is worth a lot more, if you cut down the trees and build houses or suburban communities, somebody may want to do it. And then you run into the question of whether or not it's legal to do it, whether you can do it, whether you'd still be alive when the lawsuits were ended if you tried to do it. But in order to value real estate, you look at the phrase is the highest and best use, and you try to figure out what's the best use that will generate the most value.